to return to our desk.
The Senate will convene as a court of impeachment. The chaplain will lead us in prayer.
Let us pray. Divine Shepherd, honor, glory, and power belong to you. Refresh our senators as they enter a new phase of this impeachment trial. May they realize that you have appointed them for this great service, and they are accountable to you. Lord, empower them to labor today with the dominant purpose of pleasing you, knowing that it is never wrong to do right. Give them resiliency in their toil as they remember your promise that they will reap a bountiful harvest if they don't give up. Help them to follow the road of humility that leads to honor as they find their safety in trusting you. We pray in your majestic name. Amen.
Amen. Please join me in reciting the Pledge of Allegiance to the flag.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
If there is no objection, the Journal of Proceedings of the trial are approved to date. Without objection, so ordered. The Sergeant-at-Arms will make the proclamation.
Hear ye, hear ye, hear ye. All persons are commanded to keep silent on pain of imprisonment, while the Senate of the United States is sitting for the trial of the articles of impeachment exhibited by the House of Representatives against Donald John Trump, President of the United States.
The Majority Leader is recognized.
Today, the Senate will conduct up to 8 hours of questions to the parties delivered in writing to the Chief Justice. As a reminder, the two sides will alternate and answers should be kept to 5 minutes or less. The majority side will lead off with a question from the senator from Maine.
Mr. Chief Justice.
The senator is recognized.
I send a question to the desk. On behalf of myself, Senator Murkowski, and Senator Romney.
This is a question for the counsel for the President. If President Trump had more than one motive for his alleged conduct, such as the pursuit of personal political advantage, rooting out corruption, and the promotion of national interests, how should the Senate consider more than one motive in its assessment of Article 1?
Mr. Chief Justice, Senators, in response to that question, there were really two layers to my answer, because I'd like to point out first that even if there was only one motive, the theory of abuse of power that the House managers have presented, that subjective motive alone can become the basis for an impeachable offense, we believe is constitutionally defective. It is not a permissible way to frame a claim of an impeachable offense under the Constitution. But I'll put that to one side and address the question of mixed motive. If there were a motive that was a public interest but also some personal interest, we think it follows even more clearly that that cannot possibly be the basis for an impeachable offense. And even the House managers, as they have framed their case, they have explained, and this is pointed out in our trial memorandum, that in the House Judiciary Committee report, they specify that the standard they have to meet is to show that this is a sham investigation. It's a bogus investigation. These investigations there's not any legitimate public purpose. That's the language, any legitimate public purpose. That's the standard they've set for themselves in being able to make this claim under their theory of what an abuse of power offense can be. So it's a very demanding standard that they've set for themselves to meet. And they've even said they came up and they talked a lot about the Bidens. They talked a lot about these issues in 2016 election interference, because they were saying there's not even a scintilla of any evidence of anything worth looking into there. And that's the standard that they would have to meet, showing that there's no possible public interest and the president couldn't have had any smidgen even of a public interest motive, because they recognize that once you get into a mixed motive situation, if there's both some personal motive but also a legitimate public interest motive, it can't possibly be an offense. Because it would be absurd to have the Senate trying to consider, well, was it 48% legitimate interest and 52% personal interest, or was it the other way? Was it 53% and 40%? You can't divide it that way. And that's why they recognize that to have even a remotely coherent theory, the standard they have to set for themselves is establishing there is no possible public interest at all for these investigations. And if there is any possibility, if there is something that shows a possible public interest, and the president could have that possible public interest motive, that destroys their case. So once you're into mixed motive land, it's clear that their case fails. There can't possibly be an impeachable offense at all. And think about it. All elected officials, to some extent, have in mind how their conduct, how their decisions, their policy decisions, will affect the next election. There's always some personal interest in the electoral outcome of policy decisions. And there's nothing wrong with that. That's part of representative democracy. And to go start saying now that, well, if you've got a part motive that's for your personal electoral gain, that that's somehow going to become an offense, it doesn't make any sense. And it's totally unworkable. And it can't be a basis for removing a president from office. So the bottom line is, once you're into any mixed motive situation, once it is established that there is a legitimate public interest that could justify looking into something, just asking a question about something, the manager's case fails, and it fails under their own terms. They recognize that they have to show no possible public interest. There isn't any legitimate public interest. And they've totally failed to make that case. I think we've shown very clearly that both of the things that were mentioned, 2016 election interference and the Biden-Burisma situation, are things that raise at least some public interest. There's something worth looking at there. It's never been investigated in the Biden situation. Lots of their own witnesses from the State Department said that on its face it appears to be a conflict of interest. It's at least worth raising a question about, asking a question about it. And there is that public interest, and that means their case absolutely fails. Thank you.
Thank you, counsel. The Democratic leader is recognized.
Mr. Chief Justice, I send the question to the desk.
The Democratic leader asks the House managers. John R. Bolton's forthcoming book states that the president wanted to continue withholding $391 million in military aid to Ukraine until Ukraine announced investigations into his top political rival and the debunked conspiracy theory about the 2016 election. Is there any way for the Senate to render a fully informed verdict in this case without hearing the testimony of Bolton, Mulvaney, and the other key eyewitnesses, or without seeing the relevant documentary evidence?
Thank you, Mr. Chief Justice. The short answer to that question is no. There's no way to have a fair trial without witnesses. And when you have a witness who is as plainly relevant as John Bolton, who goes to the heart of the most serious and egregious of the president's misconduct, who has volunteered to come and testify, to turn him away, to look the other way, I think is deeply at odds with being an impartial juror. I would also add in response to the last question that if any part of the president's motivation was a corrupt motive, if it was a causal factor in the action to freeze the aid or withhold the meeting, that is enough to convict. It would be enough to convict under criminal law. But here there's no question about the president's motivation. And if you have any question about the president's motivation, it makes it all the more essential to call the man who spoke directly with the president, that the president confided in and said he was holding up this aid because he wanted Ukraine to conduct these political investigations that would help him in the next election. If you have any question about whether it was a factor, the factor, a quarter of the factor, all of the factor, there is a witness, a subpoena away who can answer that question. But the overwhelming body of the evidence makes it very clear. On July 26th, the day after that phone call, Donald Trump speaks to Gordon Sondland. That's that conversation at Ukraine restaurant. And what does Gordon Sondland, what is the president's question of Gordon Sondland the day after that call? Is he going to do the investigations? Now, counsel, the president would have you believe the president was concerned about burden sharing. Well, he may have had a generic concern about burden sharing in other contexts. But here, the motivation was abundantly clear. On that phone with Gordon Sondland, the only question he wanted an answer to was, is he going to do the investigation? Now, bear in mind, he's talking to the ambassador to the European Union. What better person to talk to if his real concern was about burden sharing than the guy responsible for Europe's burden sharing? But did the president raise this at all? Of course not. Of course not. And if you have any question about it at all, you need to hear from his former national security advisor. Don't wait for the book. Don't wait till March 17th, when it is in black and white, to find out the answer to your question. Was it all the motive, some of the motive, or none of the motive? Now, we think, as I mentioned, the case is overwhelmingly clear without John Bolton, but if you have any question about it, you can erase all doubt. Now, let me show you a video, underscore number 2, slide 2, how important this is.
As House managers, really, their goal should be to give you all of the facts, because they're asking you to do something very, very consequential. And ask yourself, given the facts you heard today that they didn't tell you, who doesn't want to talk about the facts? Who doesn't want to talk about the facts? Impeachment shouldn't be a shell game. They should give you the facts.
Last video, which is even more important and on point for Mr. Bolton. Number 3.
And once again, not a single witness in the House record that they compiled and developed under their procedures that we've discussed and will continue to discuss provided any firsthand evidence that the president ever linked a presidential meeting to any investigations. Anyone who spoke with the president said that the president made clear that there was no linkage between security assistance and investigations.
No, that's not correct, right? Because, of course, Mick Mulvaney said that the money was linked to these investigations. He said, in acknowledging a quid pro quo, they do it all the time and we should just get over it. Gordon Sondland also said, the president said, on the one hand, no quid pro quo, but also made it clear that Zelensky had to go to the mic and announce these investigations.
Thank you.
Thank you, Justice.
Mr. Chief Justice,
Senator Thune.
I have a question for the President's counsel.
To the President's counsel, would you please respond to the arguments or assertions the House managers just made in response to the previous question?
Mr. Chief Justice, Senators, a couple of points that I'd like to make. Manager Schiff suggested that there was no evidence the president was actually interested in burden sharing because he didn't apparently, according to David Hale, raise it in the telephone conversation that he had with Gordon Sondland that Hale claims to have overheard at a restaurant in Kiev. But let's look at the real evidence. As we explained, on June 24th, there is an email in the record showing, it's an email from one person at the Department of Defense to another with a subject line of POTUS follow-up, President of the United States follow-up, asking specifically about burden sharing. It says, quote, what do other NATO members spend to support Ukraine, end quote. That was what they were following up on for the president. And in the transcript itself, in the transcript of the July 25th call itself, the president asked, he said, we spend a lot of effort and a lot of time for Ukraine, much more than the European countries are doing, and they should be helping you more than we are. Germany does almost nothing for you. All they do is talk, and I think it's something you should really ask them about. And he goes on to say that he talks to Angela Merkel about it, and that they're not really doing as much as the United States is doing. He's raising burden sharing, and President Zelensky agreed with him. Now, Manager Schiff also suggested that there is evidence of some connection between the military assistance and investigations into 2016 election interference because of a statement that Acting Chief of Staff Mulvaney made at a press conference. But it's been clear in the record since that press conference that what he was saying was garbled and or misunderstood, and he immediately clarified and said on that day, quote, the president never told me to withhold any money until the Ukrainians did anything related to the server, end quote. And similarly, he issued a statement just the other day making clear again that he said, this is from his counsel, so it's phrased in the third person, nor did Mr. Mulvaney ever have a conversation with the president or anyone else indicating that Ukrainian military aid was withheld in exchange for Ukrainian investigation of Burisma, the Bidens, or the 2016 election. That is Mr. Mulvaney's statement. Lastly, onto the point of whether this chamber should hear from Ambassador Bolton. And I think it's important to consider what that means, because it's not just a question of, well, should we just hear one witness? That's not what the real question is going to be. For this institution, the real question is, what is the precedent that is going to be set for what is an acceptable way for the House of Representatives to bring an impeachment of a President of the United States to this chamber? And can it be done in a hurried, half-baked, partisan fashion without, they didn't even subpoena John Bolton below. They didn't even try to get his testimony. And to insist now that this body will become the investigative body, that this body will have to do all the discovery, and that this institution will be effectively paralyzed for months on end because it has to sit as a court of impeachment, while now discovery is done because it would be Ambassador Bolton, and if there are going to be witnesses, then the president would have to, in order, they said fair trial, fair adjudication, then the president would have to have his opportunity to call his witnesses. And there'd be depositions, and this would drag on for months. And then that's the new precedent. Then that's the way all impeachments operate in the future. The House doesn't have to do the work. They do it quick. They throw it over the transom, and this institution gets derailed and has to deal with it. And that should not be the way, that should not be the precedent that is set here for the way this body will have to handle all impeachments in the future. Because if it becomes that easy for the House to do it, they'll be doing it a lot. Thank you.
The senator from Massachusetts.
Send a question to the desk.
Question from Senator Markey to the House managers. On Monday, President Trump tweeted, "The Democrat-controlled House never even asked John Bolton to testify." End quote. So that the record is accurate, did House impeachment investigators ask Mr. Bolton to testify?
Senators, the answer is yes. Of course, we asked John Bolton to testify in the House, and he refused. We asked his deputy, Dr. Kupperman, to testify, and he refused. Fortunately, we asked their deputy, Dr. Fiona Hill, to testify, and she did. We asked her deputy, Colonel Vindman, to testify, and he did. But we did seek the testimony of John Bolton as well as Dr. Kupperman, and they refused. When we subpoenaed Dr. Kupperman, he sued us, took us to court. When we raised a subpoena with John Bolton's counsel, the same counsel for Dr. Kupperman, the answer was, Senator, you serve us with a subpoena and we will sue you too. We knew, based on the McGahn litigation, it would take months, if not years, to force John Bolton to come and testify. And I should point out, because I think this is an essential point to underscore, as the president's lawyers say, they didn't try hard enough to get John Bolton, or they should have subpoenaed John Bolton. That's what they're telling you. But let me show you what they're telling the court in the McGahn litigation. If we could pull up slide number 39. This is the president's lawyers in court in the McGahn litigation. In the Court of Appeals right now, quote, "The committee," meaning our committee, "lacks Article III standing to sue to enforce a congressional subpoena demanding testimony from an individual on matters related to duties as an executive branch official." I mean, it takes your breath away, the duplicity of that argument. They're before you saying they should have tried harder to get these witnesses, they should have subpoenaed, they should have litigated for years, and down the street in the federal courthouse, they're arguing, "Judge, you need to throw them out. They have no standing to sue to force a witness to testify." Are we really prepared to accept that? Now, counsel says, think about the precedent that we would be setting if you allow a House to impeach a president and you permit them to call witnesses. Well, I would submit, think about the precedent you will be setting if you don't allow witnesses in a trial. That, to me, is the much more dangerous precedent here. But I'll tell you there's something even more dangerous, and this was something that we anticipated from the very beginning, which is we understood when we got to this point they could no longer contest the facts that the president withheld military aid from an ally at war to coerce that ally to doing the president's political dirty work. So now they have fallen back on, you shouldn't hear any further evidence, any further witnesses on this subject. What's more, we're going to use the end-all argument, so what? A president is free to abuse their power. We're going to rely on a constitutional theory, a fringe theory, that even the advocate of which says is outside of the consensus of constitutional law, to say that a president can abuse his power with impunity. Now imagine where that leads. A president can abuse his power with impunity. Now, that argument made by Professor Dershowitz is at odds with the Attorney General's own expressed opinion on the subject, with Ken Starr's expressed opinion on the subject, with not only other counsel for the president, Jonathan Turley, who testified in the House, says that theory is constitutional, effectively nonsense. But even 60-year-old Alan Dershowitz doesn't agree with 81-year-old Alan Dershowitz. And for a reason, because where that conclusion leads us is that a president can abuse his power in any kind of way, and there's nothing you can do about it. Now, are we really ready to accept the position that this president or the next can withhold hundreds of millions of dollars in military aid to an ally at war unless they get help in their reelection? Would we say that you could, as president, withhold disaster relief from a governor unless that governor got his attorney general to investigate the president's political rival? That, to me, is the most dangerous argument of all. It's a danger to have a president who engage in this conduct. It's a danger to have a trial with no witnesses and set that precedent. But the biggest danger of all, I think, would be to accept the idea that a president can abuse his office in this way, and the Congress is powerless to do anything about it. That is certainly not what the founders intended.
Mr. Chief Justice.
The senator from Tennessee.
Thank you, Mr. Chief Justice. I send a question to the desk on my behalf and also joined by Senators Loeffler, Lee, Kramer, and McSally.
The senators ask of counsel for the president, is the standard for impeachment in the House a lower threshold to meet than the standard for conviction in the Senate? And have the House managers met their evidentiary burden to support a vote of removal?
Mr. Chief Justice, Senators, the standard in the House, of course, the House is not making a final determination in the structure of the Constitution. An impeachment is simply an accusation. And as in most systems where there is simply an accusation being made, the House does not have to adhere to the same standard that is used in the Senate. In most instances, House members have suggested in debates on articles of whether or not to approve articles of impeachment that they should have clear and convincing evidence in the view of the members voting on it that there was some impeachable offense, and that is all. Some not even that standard. And so it is simply enough evidence that an accusation can be made. It is definitely a lower standard than the standard that has to be met here on a trial for an ultimate verdict. The Constitution speaks in terms of a conviction in the Senate. And as both Professor Dershowitz and Judge Starr pointed out in their comments, everywhere in the Constitution that there is any mention of impeachment, it is spoken of in terms of the criminal law. The offenses that define the jurisdiction for the Senate sitting as a court of impeachment are treason, bribery, and high crimes and misdemeanors. The Constitution speaks of a conviction upon being convicted in the Senate. It speaks of all crimes being tried by jury except in cases of impeachment, again suggesting notions of the criminal law. And as we pointed out in our trial memorandum, all of these textual references make it clear that the standards of the criminal law should apply in the trial, certainly to the extent of the burden and standard of proof to be carried by the House managers, which means proof beyond a reasonable doubt. And it is very clear that there is not any requirement for proof beyond a reasonable doubt simply for the House to vote upon articles of impeachment. There's a very much higher standard at stake here. As we pointed out in our trial memorandum, the mere accusation made by the House comes here with no presumption of regularity at all in its favor. The Senate sits as trier of both fact and law, reviewing both factual and legal issues de novo, and the House managers are held to a standard of proving proof beyond a reasonable doubt of every element of what would be a cognizable, impeachable offense. Here, they have failed in their burden of proof. They have also failed on the law. They have not stated in the articles of impeachment anything that on its face amounts to an impeachable offense. And on the facts, I think we have demonstrated very clearly that they have not presented facts that would amount to an impeachable offense, even under their own theories. They have presented only part of the facts and left out the key facts. And Mr. Papura, I think, went through very effectively showing that there are some facts that don't change. The transcript of the July 25th call shows the president doing nothing wrong. President Zelensky said he never felt any pressure. His other advisors have said the Ukrainians never felt any pressure. They didn't think there was any quid pro quo. They didn't even know that the military assistance had been held up until the Politico article at the end of August. The only two people with statements on record who spoke to the president, who are Sondland and Senator Ron Johnson, report that the president said to them there was no quid pro quo, and the aid flowed without anything ever being done related to investigations. That is what's in the record. That is what the House managers have to rely on to make their case, and they have failed to prove their case beyond a reasonable doubt, failed even to prove it by clear and convincing evidence, failed to prove it at all, in my opinion. Thank you.
Thank you, counsel. The senator from California is recognized.
Thank you. Mr. Chief Justice, I send a question to the House managers.
Senator Feinstein asks the House managers. The President's counsel stated that, quote, there is simply no evidence anywhere that President Trump ever linked security assistance to any investigations, end quote. Is that true?
Thank you, Mr. Chief Justice, and thank you, Senator, for that question. The President's counsel is not correct. There is, in fact, overwhelming evidence that the President withheld the military aid directly to get a personal political benefit to help his individual political campaign. There's a few points that I'd like to submit for your consideration. First, look no further than the words of the President's acting Chief of Staff, Mick Mulvaney, who on October 17th, 2019, during a national press conference, mentioned, quote, or he was asked about the direct connection between the aid, and he said, quote, did he, meaning President Trump, referring to he, quote, also mentioned to me in passing the corruption related to the DNC server? Absolutely, no question about it, but that's it. And that's why we held up the money, end quote. He was repeating the President's own explanation relayed directly to him. Second, Gordon Sondland testified he spoke by phone with President Trump on September 7th. The President denied there was a, quote, quid pro quo, but then outlined the very quid pro quo that he wanted from Ukraine. Then he told President Sondland to, quote, that President Zelensky should, quote, go to the microphone and announce the investigations. He should want to do it. Third, the president's own advisors, including the Vice President and Secretary Pompeo, were also aware of the direct connection. In Warsaw on September 1st, Ambassador Sondland told Vice President Pence that he was concerned the delay in security assistance had become, quote, tied to the issue of investigations. The Vice President simply nodded, tacitly acknowledging the conditionality of the aid. Fourth, we heard from Ambassador Taylor, who in direct emails and texts said it was crazy to tie the security assistance to the investigations. 5, we also know there's no other reason. The entire apparatus and structure of the Defense Department, the State Department, that should have been dealing with the other legitimate reasons, the policy debate that the President's Council wants you to believe that this was about, they were all kept in the dark. And the supposed interagency process that they made up several months after the fact had ended months before, during the last interagency meetings. And I'll make one final point. Again, if you have any lingering questions about direct evidence, any thoughts about anything we just talked about, anything I just relayed, or that we've talked about the last week, there is a way to shed additional light on it. You can subpoena Ambassador Bolton and ask him that question directly.
Thank you, Mr. Manager.
Mr. Chief Justice.
Senator from Utah.
I send a question to the desk.
Senator Lee asks of counsel for the President. The House managers have argued aggressively that the President's actions contravened U.S. foreign policy. Isn't it the President's place, certainly more than the place of career civil servants, to conduct foreign policy?
Thank you, Mr. Chief Justice, Senators, and thank you for that question. It is definitely the President's place to set U.S. foreign policy, and the Constitution makes this clear. Article 2, Section 1 vests the entirety of the executive authority in a President of the United States. And it's critically important in our constitutional structure that that authority is vested solely in the President, because the President is elected by the people every 4 years. That's what gives the President democratic legitimacy to have the powers that he is given under the Constitution. Our system is somewhat unique in the very broad powers that are assigned to the executive, but it works and it makes sense in a democratic system precisely because he is directly accountable to the people for the policies that he sets. Those who are staffers in the executive branch bureaucracy are not elected by the people. They have no accountability, and they have no legitimacy or authority that comes from an election by the people. And so it's critically important to recognize the President sets foreign policy. Of course, within some constraints, there's roles for Congress in foreign affairs to some extent. Statutes can be passed, funding provisions can be passed that relate to it. But the Supreme Court has recognized time and again that the President is, as the Court said in Curtis Wright, the sole organ of the nation in foreign affairs. So he sets foreign policy. And if staffers disagree with him, that does not mean that the President is doing something wrong. And this is a critical point, because this is one of the centerpieces of the abuse of power theory that the House managers would like this body to adopt. And that is that they are going to impeach the President based solely on his subjective motive. The premise of their case is the objective actions that were taken were perfectly permissible and within the President's constitutional authority. But if his real reason, if we get inside his head and figure it out, then we can impeach him. And the way that they have tried to explain that they can prove that the president had a bad motive is they say, well, we compare what did the president want to do with what the interagency consensus was. And I mentioned this the other day. They say that the president defied and confounded every agency in the executive branch. That's a constitutionally incoherent statement. The president cannot defy the agencies within the executive branch that are subordinate to him. It is only they who can defy the president's determinations of policy. And what this all boils down to, really, is it shows that this case is built on a policy difference, and a policy difference where the president is the one who gets to determine policy because he's been elected by the people to do that. And we're right now only a few months away from another election where the people can decide for themselves whether they like what the president has done with that authority or not. And that's the way disputes about policy like that should be resolved. It's not legitimate to say that there's some interagency consensus that disagrees with the president, and therefore we can show he did something wrong, and therefore he could be impeached. That's an extraordinarily dangerous proposition because it lacks any democratic legitimacy whatsoever. It's contrary to the Constitution, and it should be rejected by this body. The president is the one who gets to set foreign policy because that's the role assigned to him in the Constitution. And it was even Lieutenant Colonel Vindman, who had complained about the July 25th call, himself ultimately agreed that it was only a policy difference. It was a policy concern that he raised about the call. That's not enough to impeach a president of the United States. Thank you.
Thank you, counsel. The senator from New Hampshire.
Mr. Chief Justice, I send a question to the desk.
Senator Shaheen asks the House managers. The President's counsel has argued that the alleged conduct set out in the articles does not violate a criminal statute and thus may not constitute grounds for impeachment as high crimes and misdemeanors. Does this reasoning imply that if the President does not violate a criminal statute, he could not be impeached for abuses of power, such as ordering tax audits of political opponents, suspending habeas corpus rights, indiscriminately investigating political opponents, or asking foreign powers to investigate members of Congress?
Mr. Chief Justice, Senators, I appreciate the question. The simple answer is that a president can be impeached without a statutory crime being committed. That was the position, and the question was rejected in President Nixon's case and rejected again in President Clinton's case. It should be rejected here in President Trump's case. The great preponderance of legal authority confirms that impeachable offenses of legal authority confirms that it is not defined in criminal conduct. This authority includes nearly every legal scholar to have studied the issue, multiple Supreme Court justices who addressed it in public remarks, and prior impeachments in the House. This conclusion follows that constitutional history, text, and structure, and reflects the absurdities and practical difficulties that would result were the impeachment power confined to indictable crimes. As slide 35 shows, first, the plain text of the Constitution does not require that an offense be a crime in order for it to be impeachable. Alexander Hamilton explained that impeachable offenses, high crimes, and misdemeanors are defined fundamentally by the abuse or violation of some public trust. Some public trust. They are political as they relate chiefly to injuries done immediately to the society itself. Offenses against the Constitution are different than offenses against the criminal code. Some crimes, like jaywalking, are not impeachable, and some forms of misconduct often offend both offend the Constitution and the criminal law. Impeachment and criminality must therefore be assessed separately, even though the President's commission of indictable crimes may further support a case of impeachment and removal. The American experience with impeachment confirms this. A strong majority of impeachments voted by the House since 1789 have included one or more allegations that did not charge a violation of criminal law. Although President Nixon resigned before the House could consider the articles of impeachment against him, the Judiciary Committee's allegations encompass many, many non-criminal acts. And in President Clinton's case, the Judiciary Committee report accompanying the articles of impeachment to the House floor stated that, quote, the actions of President Clinton do not have to rise to the level of violating the federal statute regarding articles obstruction of justice in order to justify impeachment. The framers intended impeachment to reach the full spectrum of presidential misconduct that threatened the Constitution. They also intended that our Constitution endure throughout the ages. In other words, if they named 1, 2, and 3, but new ones came up, you had to keep up with the times, so it was better to have the full spectrum of presidential misconduct. Because they could not anticipate and specifically prohibit every single threat a president might someday pose, the framers adopted a standard sufficiently general and flexible to meet unknown future circumstances. This standard was meant, as Mason put it, to capture all manner of great and dangerous offenses incompatible with the Constitution. When the president uses the powers of his high office to benefit himself while injuring or ignoring the American people he is duty-bound to serve, he has committed an impeachable offense. The records of the Constitutional Convention offer further clarity. At the Constitutional Convention itself, no delegate linked impeachment to the technicalities of criminal law. Instead, the framers principally intended impeachment for 3 forms of presidential wrongdoing, the ABCs of impeachment. A, abuse of power. B, betrayal of the national interest through foreign entanglements. And C, corruption of office and elections. When a president abuses his power to obtain illicit help in his election from a foreign power and undermine our national security and election integrity, it is a trifecta.
Thank you. Thank you, counsel.
Thank you.
The senator from Louisiana.
Mr. Chief Justice, along with Senator Blackburn and Senator Cornyn, I send a question to the desk for the House managers and for counsel for the President.
In the case of such a question addressed to both sides, they will split the 5 minutes equally. The senators ask, why did the House of Representatives not challenge President Trump's claims of executive privilege and/or immunity during the House impeachment proceedings? We'll begin with the House managers. We'll have to start the clock soon.
Mr. Chief Justice, distinguished senators, thank you for your question. The answer is simple. We did not challenge any claims related to executive privilege because, as the President's own counsel admitted during this trial, the President never raised the question of executive privilege. What the President did raise was this notion of blanket defiance, this notion that the executive branch, directed by the President, could completely defy any and all subpoenas issued by the House of Representatives, not turn over documents, not turn over witnesses, not produce a single shred of information in order to allow us to present the truth to the American people. In the October 8th letter that was sent to the House of Representatives, there was no jurisprudence that was cited to justify the notion of blanket defiance. There has been no case law cited to justify the doctrine of absolute immunity. In fact, every single court that has considered any presidential claim of absolute immunity, such as the one asserted by the White House, has rejected it out of hand.
Counsel for the President.
Mr. Chief Justice, Senators, thank you for that question. Let me frame this partly in response to what Manager Jeffries said, and I went through this before. The idea that there was blanket defiance and no explanation and no case law from the White House is simply incorrect. I put up slides showing the letters, a letter from October 18th that explained specifically that the subpoenas that had been issued by the House because they were not authorized by a vote from the House were invalid. And there was a letter from the White House counsel saying that. There was a letter from OMB saying that. There was a letter from the State Department saying that. There were specific rationales given, citing the cases, Watkins, Roomley, and others, explaining that defect. The House, Manager Schiff, chose not to take any steps to correct that. We also pointed out other defects. We asserted the doctrine of absolute immunity for senior advisors to the President, which has been asserted by every president since the 1970s. They chose not to challenge that in court. We also explained the problem that they didn't allow agency counsel to be present at depositions. They chose not to challenge that in court. These were specific legal reasons, not blanket defiance, right? That's just a misrepresentation of the record. And there was no attempt to have that adjudicated in court. And the reason that there was no attempt is that the House Democrats were just in a hurry. They had a timetable. One of the House managers said on the floor here, they had no time for courts. They had to impeach the president before the election. So they had to have that done by Christmas. That's why the proper process wasn't followed here, because it was a partisan and political impeachment that they wanted to get done all around timing for the election. Thank you.
Thank you, counsel. Senator from Vermont. Senator Leahy asks the House managers, the President's counsel argues that there was no harm done, that the aid was ultimately released to Ukraine, the President met with Zelensky at the UN in September, and that this President has treated Ukraine more favorably than his predecessors. What is your response?
Mr. Chief Justice and Senator, thank you so much for your question. Contrary to what the White House counsel has said or has claimed, that there was no harm, no foul, that the aid eventually got there, We promised Ukraine in 2014 that if they gave up their nuclear arsenal, that we would be there for them, that we would defend them, that we would fight along beside them. 15,000 Ukrainians have died. It was interesting the other day when the White House counsel said that no American life was lost, and we are always grateful and thankful for that. But what about our friends? What about our allies in Ukraine? According to Diplomat Holmes and Ambassador Taylor, that our Ukrainian friends continue to die on the front lines, those who were fighting for us, fighting Russian aggression. When you fight Russian aggression, when the Ukrainians have the ability to defend themselves, they have the ability to defend us. The aid, although it did arrive, it took the work of some senators in this room who had to pass additional laws to make sure that the Ukrainians did not lose out on $35 million additional dollars. And contrary to the president's tweet that all of the aid arrived and that it arrived ahead of schedule, that is not true. All of the aid has not arrived. And let's talk about what kind of signal withholding the aid for no legitimate reason. The president talked about burden sharing, but nothing had changed on the ground. Holding the aid for no legitimate reason sent a strong message that we would not want to send to Russia, that the relationship between the United States and Ukraine was on shaky ground. It actually undercut Ukraine's ability to negotiate with Russia, with whom, as everybody in this room knows, is in an active war, in a hot war. So when we talk about the aid eventually got there, no harm, no foul, that is not true, senators, and I know that you know that. There was harm and there was foul. And let us not forget that Ukraine is not an enemy. They're not an adversary. They are our friends.
Thank you. Senator Cruz.
Mr. Chief Justice, I send a question to the desk. Thank you.
The question is addressed to counsel for the President. As a matter of law, does it matter if there was a quid pro quo? Is it true that quid pro quos are often used in foreign policy?
Chief Justice, thank you very much for your question. Yesterday, I had the privilege of attending the rolling out of a peace plan by the President of the United States regarding the Israel-Palestine conflict. And I offered you a hypothetical the other day. What if a Democratic president were to be elected and Congress were to authorize much money to either Israel or the Palestinians, and the Democratic president were to say to Israel, no, I'm going to withhold this money unless you stop all settlement growth, or to the Palestinians, I will withhold the money Congress authorized to you unless you stop paying terrorists. And the president said, quid pro quo. If you don't do it, you don't get the money. If you do it, you get the money. There's no one in this chamber that would regard that as in any way unlawful. The only thing that would make a quid pro quo unlawful is if the quo were in some way illegal. Now, we talked about motive. There are three possible motives that a political figure can have. One, a motive in the public interest, and the Israel argument would be in the public interest. The second is in his own political interest, and the third, which hasn't been mentioned, would be in his own financial interest, his own pure financial interest, just putting money in the bank. I want to focus on the second one for just one moment. Every public official that I know believes that his election is in the public interest. And mostly you're right. Your election is in the public interest. And if a president does something which he believes will help him get elected in the public interest, that cannot be the kind of quid pro quo that results in impeachment. I quoted President Lincoln. When President Lincoln told General Sherman to let the troops go to Indiana so that they can vote for the Republican Party. Let's assume the president was running at that point, and it was in his electoral interest to have these soldiers put at risk the lives of many, many other soldiers who would be left without their company. Would that be an unlawful quid pro quo? No, because the president, A, believed it was in the national interest, but B, he believed that his own election was essential to victory in the Civil War. Every president believes that. That's why it's so dangerous to try to psychoanalyze a president, to try to get into the intricacies of the human mind. Everybody has mixed motives. And for there to be a constitutional impeachment based on mixed motives would permit almost any president to be impeached. How many presidents have made foreign policy decisions after checking with their political advisors and their pollsters? If you're just acting in the national interest, what do you need pollsters? What do you need political advisors? Just do what's best for the country. But if you want to balance what's in the public interest with what's in your party's electoral interest and your own electoral interest, it's impossible to discern how much weight is given to one to the other. Now, we may argue that it's not in the national interest for a particular president to get reelected or for a particular senator or member of Congress. And maybe we're right. It's not in the national interest for everybody who's running to be elected. But for it to be impeachable, you would have to discern that he or she made a decision solely on the basis of, as the House managers put it, corrupt motives. And it cannot be a corrupt motive if you have a mixed motive that partially involves the national interest, partially involves electoral, and does not involve personal pecuniary interests. And the House managers do not allege that this decision, this quid pro quo, as they call it, and the question is based on the hypothesis there was a quid pro quo, I'm not acting the facts, they never allege that it was based on pure financial reasons. It would be a much harder case if a hypothetical president of the United States said to a hypothetical leader of a foreign country, unless you build a hotel with my name on it, and unless you give me $1 million kickback, I will withhold the funds. That's an easy case. That's purely corrupt and in the purely private interest. But a complex middle case is, I want to be elected. I think I'm a great president. I think I'm the greatest president there ever was. And if I'm not elected, the national interest will suffer greatly. That cannot be an impeachable offense. Thank you, Mr. Chief Justice.
Recognize the Democratic leader.
Mr. Chief Justice, I send a question to the desk.
The question is for the House managers. Would you please respond to the answer that was just given by the President's counsel?
I would be delighted. There are two arguments that Professor Dershowitz makes. One that is, I have to say, a very odd argument for a criminal defense lawyer to make, and that is, it is highly unusual to have a discussion in a trial about the defendant's state of mind, intent, or mens rea. In every courtroom in America, in every criminal case, or almost every criminal case, except for a very small sliver that are strict liability, the question of the defendant's intent and state of mind is always an issue. So this is nothing novel here. You don't require a mind reader in every criminal case, And I would assume in every impeachment case, yes, you have to show that the president was operating from a corrupt motive, and we have. But he also makes an argument that all quid pro quos are the same and all are perfectly copacetic. Now, some of you said earlier, well, if they could prove a quid pro quo over the military, now that would be something. Well, we have. So now the argument shifts to all quid pro quos are just fine, they're all the same. Well, I'm going to apply Professor Dershowitz's own test. He talked about the step test. John Rawls, the philosopher, let's put the shoe on the other foot and see how that changes our perception of things. But I want to merge that argument with one of the other presidential counsel's argument when they resorted to the whataboutism about Barack Obama's open mic. Now, that was a very poor analogy, I think you'll agree, but let's use that analogy and let's make it more comparable to today and see how you feel about this scenario. President Obama, on an open mic, says to Medvedev, hey, Medvedev, I know you don't want me to send this military money to Ukraine because they're fighting and killing your people. I want you to do me a favor, though. I want you to do an investigation of Mitt Romney. And I want you to announce you found dirt on Mitt Romney. And if you're willing to do that, quid pro quo, I won't give Ukraine the money they need to fight you on the front line. Do any of us have any question that Barack Obama would be impeached for that kind of misconduct? Are we really ready to say that that would be okay if Barack Obama asked Medvedev to investigate his opponent and would withhold money from an ally that it needed to defend itself to get an investigation of Mitt Romney? That's the parallel here. And to say, well, yes, we condition aid all the time, for legitimate reasons, yes. For legitimate reasons, you might say to a governor of a state, hey, governor of a state, you should chip in more towards your own disaster relief. But if the president's real motive in depriving a state of disaster relief is because that governor won't get his attorney general to investigate the president's political rival, are we ready to say that the president can sacrifice the interests of the people of that state, or in the case of Medvedev, the people of our country, because all quid pro quos are fine, it's carte blanche? Is that really what we're prepared to say with respect to this president's conduct or the next? Because if we are, then the next president of the United States can ask for an investigation of you. They can ask for help in their next election from any foreign power. And the argument will be made, nope, Donald Trump was acquitted for doing exactly the same thing. Therefore, it must not be impeachable. Now, bear in mind that efforts to cheat an election are always going to be in proximity to an election. And if you say you can't hold a president accountable in an election year where they're trying to cheat in that election, then you are giving them carte blanche. So all quid pros are not the same. Some are legitimate and some are corrupt, and you don't need to be a mind reader to figure out which is which. For one thing, you can ask John Bolton.
Thank you, Mr. Manager.
Mr. Chief Justice.
Senator from Iowa.
I send a question to the desk.
Senator Grassley asks counsel for the President, does the House's failure to enforce its subpoenas render its, quote, obstruction of Congress, end quote, theory unprecedented?
Mr. Chief Justice, Senators, the answer is yes. As far as I am aware, there has never been a prior instance in which there's been an attempt, even in the House, as in the Nixon proceeding, never mind in the Clinton proceeding, which actually left the House and came to the Senate, to suggest that there can be obstruction of Congress when there hasn't been anything beyond simply issuing a subpoena, getting resistance and then throwing up your hands and giving up and saying, oh, well, that's obstruction. In the Clinton situation, most of the litigation was with the independent counsel, and there were privileges asserted and litigation again and again. But the point is that the issues about the privileges were all litigated, and they were resolved before things came to this body. Similarly, in the Nixon impeachment proceeding within the House, a lot of investigation had been done by the special counsel, and there was litigation over assertions of privileges there in order to get at the tapes, and some tapes or transcripts had already been turned over. But again, there was litigation about the assertion of the privilege in response to the grand jury subpoena that then fed into the House's proceedings. So it would be completely unprecedented for the House to attempt to actually bring a charge of obstruction into the Senate where all they can present is, well, we issued a subpoena and there were legal grounds asserted for the invalidity of the subpoena, and there were different grounds as I've gone through. I won't repeat them all in detail here, but some were because the subpoenas were just invalid when issued because there was no vote. Some is that the subpoenas for witnesses were invalid because senior advisors to the president had absolute immunity from compulsion. Some were that they were forcing executive branch officials to testify without the benefit of agency counsel and executive branch counsel with them. So various reasons asserted for the invalidity and the defects in various subpoenas, and then no attempt to enforce them, no attempt to litigate out what the validity or invalidity might be, but just bring it here as an obstruction charge is unprecedented. And I'll note the House managers have said, and I'm sure that they will say again today, that, well, but if we had gone to court, the Trump administration would have said that the courts don't have jurisdiction over those claims. Now, that is true. In some cases, there's one being litigated right now related to the former counsel to the president, Don McGahn. The Trump administration position, just like the position of the Obama administration, is that an effort by the House to enforce a subpoena in Article III court is a non-justiciable controversy. That is our position, and we would argue that in court. But that's part of what would have to be litigated. That doesn't change the fact that the House managers can't have it both ways. And I want to make this clear. The House managers want to say that they have an avenue for going to court. They're using that avenue for going to court. They actually told the court in McGahn that once they reached an impasse with the executive branch, the courts were the only way to resolve the impasse. And as I explained the other day, there are mechanisms for dealing with these disputes between the executive and Congress. The first is an accommodations process. They didn't do that. We offered to do that in the White House counsel's October 8th letter. They didn't do accommodations. If they think they can sue, they have to take that step because the Constitution, the courts have made clear, require incrementalism in disputes between the executive and the legislative branch. So if they think that the courts can resolve that dispute, that's the next step. They should do that and have that litigated. And then things can proceed on to a higher level of confrontation. But to jump straight to impeachment, to the ultimate constitutional confrontation, doesn't make sense. It's not the system that the Constitution requires, and it is unprecedented in this case. Thank you.
Thank you, counsel. The senator from Michigan.
Thank you, Mr. Chief Justice. I send a question to the desk.
Senator Stabenow asked the House managers, would the House managers care to correct the record on any falsehoods or mischaracterizations in the White House's opening arguments?
Mr. Chief Justice and Senators, thank you for that question. We believe that the President's team has claimed basically there were 6 facts that have not been met and will not change, and All 6 of those so-called facts are incorrect. Let's be clear, on July 25th, that's not the whole evidence before us, even though it includes devastating evidence of the president's scheme. President Trump's intent was made clear on the July 25th call, but we had evidence of information before the meetings with Mr. Bolton, the text message to Mr. Zelensky's people telling him he had to do the investigations to get what he wanted. All of this evidence that makes us understand that phone call even more clearly. Now, the president's team claimed that Mr. Zelensky and other Ukrainians said they never felt pressure to open investigations. Now, of course, they didn't say that publicly. They were afraid of the Russians finding out. But Zelensky said privately that he didn't want to be involved in U.S. domestic politics. He resisted announcing the investigations. He only relented and scheduled the CNN meeting after it became clear that he was not going to receive the support that he needed and that Congress had provided in our appropriations. That's the definition of pressure. Now, Ukraine, the president's lawyers say, didn't know that Trump was withholding the security assistance until it was public. Many witnesses have contested that, including the open statement by Olena Zirkle, who was then the deputy foreign minister of Ukraine, that they knew about the president's hold on the security matters. And in the end, everyone knew it was public. And after it was, Ukraine did relent and schedule that testimony. Fourth, they said no witnesses said security was conditioned on the investigations. Not so. Mulvaney, we had other witnesses talking about the shakedown for the security assistance. But the important thing is that you can get a witness who talked to the president firsthand about what the president thought he was doing. Ultimately, of course, the funds, or at least some of them, were released. But the White House meeting that the president promised 3 different times still has not occurred. So, and we still don't have the investigation of the Bidens. Getting caught doesn't mitigate the wrongdoing. The president's unrepentant, and we fear he will do it again. Now, the Independent Government Accountability Office concluded that the president violated federal law when he withheld that aid. That misconduct is still going on. All the aid has not yet been released. And finally, I'd just like to say there's been some confusion, I think, I'm sure not intentional, but the president surely does not need the permission of his staff about foreign policy. That information is offered to you as evidence of what he thought he was doing. And he did not appear to be pursuing a policy agenda. He appeared, from all the evidence, to be pursuing a corruption of our election that's upcoming, a high crime and misdemeanor that requires conviction and removal. I yield back.